One of the frustrating and maddening things about this arraignment and indictment of President Donald Trump is that you can turn on any channel anywhere in this country, maybe even around the world, and get a legal expert who will tell you exactly what the law says and exactly what's going to happen. The problem is they all contradict each other. It's almost like you could get a lawyer to pretty much interpret the law any way you want. That's not good. We can't even get them to agree on what law applies in the case of a presidential records case. Joining us right now is Jordan Sekulow. Maybe he can sort through this for us. He, of course, is the Executive Director of American Center for Law and Justice and the host of the Secular Radio Show on the Salem Radio Network. You get what I'm saying here, Counselor. Anywhere you go, you'll get, oh, this is exactly what this means, and they all contradict each other. Where do we go from here on this?
And the reason they do is because it's unprecedented to bring charges like this against the president and to use the weakest part of the Espionage Act. It's not the part of the Espionage Act that most people think of when they think of Snowden or they think of military leakers or even going back to the Rosenberg leaks, which can carry the death sentence. This is the statute, the code before that provision, which is just about having classified documents and then not returning them when asked. But of course, we know President Trump was in a process going through it with the National Archives and Records Administration in a back and forth, trying to figure out what were his records, what were the records for National Archives, and then all of a sudden last August, Mar-a-Lago gets raided because they don't think he's doing it quickly enough.
Right.
I mean, that's the normal process, though, is that there is a back and forth between National Archives and the previous president on what documents he gets to keep and what documents they need returned. And so why we're not still just going through that process instead of bringing criminal proceedings is actually, you could say it's the big question, but we all know what it's about.
Right. It's political. And I do want to get into that aspect because it's so damaging and so destructive to the foundations that our country is built on and how we sort of make our way through the day. But on the minutia of the law here, I hear some people say, well, the Presidential Records Act supersedes all of this and there's precedent there. But other people say, well, these weren't presidential records. These were created by an agency and therefore it's actually a record of the federal government. Is there any prevailing jurisprudence that governs this?
I mean, there's been the cases, obviously the Clinton tapes case, which is not totally on point. Because
is this the sock drawer thing that President Trump was referring to? The sock drawer case,
yes, that everybody gets talking about. And yes, to some of those records that may be on point, maybe not to all of them, which is that he kept those as a kind of a personal diary, and that's what the court found there. But what the bigger issue that the court found, and the government wasn't willing to, there was not an appeal there it was Judicial Watch. They took this as kind of the final ruling, which is that courts are not going to look into this. So that's what Jack Smith has really got to be concerned about on appeal, if this case does go on appeal or provisions of it go on appeal, is that the higher up you go in federal courts, the less they want to get involved in the politics between two executive branches fighting it out over whose document is whose and who has the power to declassify this and who should have this, who shouldn't have this. Ultimately here, we are looking at basically the allegation, and what's absurd about it is what kind of shocks, and I think should shock everyone, is that if Donald Trump is convicted, and this was held up in court, which I don't think will happen, but if it was, this would mean that the current President of the United States okayed the current Attorney General at the Department of Justice to allow a special prosecutor to bring forward charges that would put President Trump in prison for the rest of his life.
Yeah.
For the rest of his life, because of pieces of paper that weren't returned potentially on time or that they were negotiating over. So yeah. I don't think the Presidential Record Act totally overrides the Espionage Act of 1917, but I do think it adds some more clarity into what presidents can say is, hey, I had a good faith argument that this was mine, that this is not yours, that this is mine. And so the weirdest part about the whole charge is that it's not the section of the Espionage Act in the code that requires you to actually do anything with the information. So it's not the sheer.
It's just the sheer possession of it, not
just the sheer.
There's no allegation that he tried to give it to a foreign enemy or an entity or anything. Yeah, it
so
is.
When that's happened before, Larry,
Sure.
all we've literally seen out of the courts is nothing. Usually the cases aren't brought. If they are, it's a slap on the wrist. I mean, no jail time, nothing serious. But that's not what the DOJ is lining up here with Jack Smith, and you see his record. He kind of doesn't care what happens on appeal. He just wants to get you convicted in the trial court and then he'll get overturned, as he often has in the high-profile political cases,
Right.
against Republicans and Democrats.
Including the one that killed the political career of the governor of Virginia,
which was horrendous.
who was seen as a rising star in the Republican Party and potentially a nominee for president.
Exactly right.
Here's the other thing that's unsettling. I keep using these words: unsettling, disquieting, because
it is.
Again, our justice system needs to be a foundation that we can, sort of feel pretty rock solid about. The fact that it's so unprecedented, everyone says it's unprecedented. This guy is the leading candidate for president against the current president. He's going to be running against him. You would think if you were going to indict this guy, there should be no question. Slam dunk. There's no, needle you have to thread to sort of justify it and make it work. And yet that seems to be the case here. All of these questions, if you've got questions, right, shouldn't the temperate thing to do is to say, okay, you know what, this is unprecedented, uncharted territory. Let's be cautious and not bring an indictment against a leading political figure running for office.
Yeah, and if we need to update laws, if we need to update rules, administrative rules, do that in light of the situation and make things more clear for future presidents so that they don't, and their staff really, so that they don't run afoul of these 1917 laws that are
right,
kind of selectively used to really prosecute people who are true enemies of the United States from within, people who do deserve that kind of violence. But when it gets down to truly is that you see a situation where, I mean, you've got, of course, the Democrats, pushing for this. As you point out, Larry, right there, if they really believed, and they're supposed to believe that, by the way, that if you bring a prosecution, that it's slam dunk. That's part of their policies, that you're going to get a conviction. You wouldn't let him out on his own recognizance. You wouldn't let him have his passport. You might try to imprison him during the trial if you thought it was that serious. But instead, they did none of that.
Yeah.
And then, so instead, it just points to the fact it's purely political. But the dangerous part is that and I love that this case is going to be tried in Miami, because so many people in Miami have fled political regimes that do this to their opponent political regimes, and they left those countries.
Are you referring to Cuba and Venezuela, or are you referring to California?
right. Cuba and Venezuela this time.
Okay.
I mean,
right.
but I think, I think again, DOJ did not want to have the case they wanted it in D.C., of course, where they'd have a friendly jury.
Sure.
But they knew that could be a 6-month battle because that's not where these alleged incidents occurred. So they had to go to Miami. Miami's a much more friendly place. I think end of the day here, President Trump's poll numbers will continue to go up, and he will ultimately beat Jack Smith and his prosecutors in court.
Quickly on this last item, Jordan Sekulow, if you don't mind. The fact that these charges have been brought in the way that they have been brought, and we've been able to look now at sort of the TikTok that's in this indictment. Clearly, presidents have dealt with this in the past. There has to be a system in place for a president to take documents from the White House to then work on their memoir or work on their presidential library. What could have been done to preempt this? Did the president get proper legal advice as this was playing out? Or do you think this is just a case of, show me the man, I'll show you the crime, nothing could have avoided this?
I'm not sure if there was any advice possible to prevent this prosecution from happening. I do think there were some steps along the way where you've seen a lot of attorneys come and go. And I've been a Trump attorney. I worked the first impeachment trial and the entire Mueller investigation for President Trump. So familiar with working with him and being direct on, this is what we need to do, Mr. President. This is what we don't need to do. And I'm not talking about tweeting. I'm not talking about speeches. I'm talking about in the actual legal issues that we were facing and how to proceed. And I think maybe they were just not up to speed on this because it is an old law. But two, my only concern was there was some lapse at some point that gave the Department of Justice and FBI time to tell a court, say, we're not getting enough back from them, so we're going to get a raid. And a judge agreed with that, whether that was right or wrong. What I would have done differently is made sure that there was a constant communication channel open so that was never going to occur. So you have your attorneys on the phone literally every day, multiple times a day, with those National Archives attorneys, with DOJ and FBI if necessary, saying we are working on complying step by step. We might have some objections, but we want to handle this correctly. There was that window that I was very concerned about, that sometimes it seems like things kind of, it just gave the FBI an opportunity that they shouldn't have had.
Jordan Sekulow, Sekulow Radio Show on the Salem Radio Network. He's going to be a very valuable voice as this unfolds. There's more to come on O'Connor tonight.